All right, thank you very much for that, General Dunlap. So what we thought we would do is just go in this order and take 12 or 14 minutes each and then see what sort of questions might arise. So what I'm going to talk about is the Newport Manual on the Law of Naval Warfare. And this developed beginning about 4 or so, 5 years ago when Professor Pedrozo and I were involved in revising the San Remo Manual on the international law applicable to armed conflicts at sea, which has been somewhat of a staple as really the only academic work, a distillation of the law of naval warfare since it was published in 1994. And so we were involved with the ICRC and the International Institute of Humanitarian Law to revise that manual. And that process, for a variety of reasons, collapsed. And we had us and some of the other participants had some different perspectives. One of them is that it was sort of a miniature United Nations. And so you had kind of rando reps from rando countries that were not really invested in the law of naval warfare. I believe in the sovereign equality of states, but what is Ghana going to offer about the law of naval warfare? They have no experience in the matter. And they also had Russia and China, sort of our favorite spoilers involved in that. And then on top of it, the ICRC had a 80% supermajority for any of the changes for the 1994 manual. And so we had some differences with that manual. We thought that there were some changes that need to be pursued. And then I think the final thing is that it was expected that the process to revise the San Remo manual would take 7 years. And we and some of our other colleagues were quite concerned about that because we thought that the fleet and our coalition partners needed something in less time than that. So Pete and I got together with Professor Wolfgang Heinig in Germany, a UK Royal Navy Judge Advocate, James Ferrant, 2 retired Royal Australian Navy Commodore Judge Advocates, Dave Letts and Rob McLaughlin, an Indian naval officer, a senior captain who teaches at their war college, who's the expert on the subcontinent on the law of the sea and the law of naval warfare. And then finally, 2 colleagues from Japan, one who is the expert on law of naval warfare for the Japan Maritime Self-Defense Force, and the other one, a professor at the National Defense Academy. And so with that group, a smaller group and sort of more agile group, we decided to go ahead and develop the Newport Manual and left the San Remo Manual project. The reason that we thought we needed it is because there's an increased likelihood of conflict, and the conflict with China is anticipated to be a maritime conflict. East Asia is a maritime domain. And there was not anything that was current and that actually reflected the law, reflected state practice or lex lata. There's lots of opinions that people can offer, sort of lex ferenda of what they wish the law were, but we wanted a authoritative guide of what the law actually is. And in the realm of the law of naval warfare, it's primarily customary law. It's not really codified in any single place. Furthermore, the San Remo Manual was out of date and incomplete. It did not accommodate certain issues such as unmanned vessels. And so we needed to include that. It didn't include cyber issues and the rest of it. So we developed this as a handbook, essentially, for judge advocates of naval forces that might operate either in East Asia or Mediterranean, Black Sea, and around the world. Because it is lex lata, based on state practice, we harvested numerous examples from previous naval conflicts, such as the Falklands conflict, the tanker war in the Persian Gulf, the Indo-Pakistan conflict, Israel, Gaza, Sri Lanka, and many others. And so that is another sort of discriminator of looking at what the law, what states have actually done. The other thing about that is that state practice is not entirely uniform, and that there are sort of broader guardrails and lower guardrails on what is accepted state practice in the law of naval warfare than the traditional land-based international humanitarian law. And so, for example, even though there's been a revolution in jus ad bellum since the adoption of the UN Charter in 1945, there hasn't been a lot of change in the law of naval warfare jus in bello. And consequently, we even looked at examples from Imperial Japan and from Germany during World War I and World War II that were useful. So this is an academic work. It's a work of scholarship. It is not official U.S. government, U.S. Navy, U.S. Coast Guard, U.S. Marine Corps perspective. If you would like that perspective, it's included in another work that is done in the Stockton Center, and that's the Commander's Handbook on the Law of Naval Operations, naval warfare publication that you can find on the internet. And there's also, this is also, some of this, a little bit of it is reflected in the DoD Law of War Manual, but unfortunately, the DoD Law of War Manual is quite superficial in its treatment. Okay, so there's some distinct differences between the traditional law of armed conflict, in which we have a lot of experience over the past 20 years of conflicts in Iraq and Afghanistan, Central Asia, but there's not very much experience at all with the law of the sea, let alone the law of naval warfare. And so we hope that this will somewhat fill the void. The DoD Law of War Manual, for example, does have a chapter on the law of naval warfare, but it's only 40 pages out of about 1,300, or about 3% of that body of work. And that's, why is that? That's because it's hard and people are not familiar with it. People are more familiar with the issues that we've been dealing with for the past 20 years in Central Asia. So essentially, there is an enormous void in the law of naval warfare that we hope to build to develop institutional expertise in the United States and with our partners around the world. If you look at the law of naval warfare, there's different missions to be accomplished on land at sea rather than on land. There's also different humanitarian considerations, and then there's something completely different, which is the economic aspect, or the dimension of international trade and all of the rules of maritime neutrality and prize capture. So there's really a confluence of four bodies of law. There's the conduct of hostilities, and even though the conduct of hostilities is different, treated differently from the land to the sea. And so we cover the methods as well as the means of naval warfare. And there's even differences in how victims of conflict and civilians are protected. There's a greater component of neutrality in the law of naval warfare. There is the law of neutrality in land-based conflict, but it's actually much more manifest in naval warfare because ships interact at sea. There's also this element of prize law, which is actually completely different than warfare on land, because belligerents may capture enemy merchant vessels and their civil aircraft and just convert them through judicial process. And they can also take the enemy goods that are located on those vessels anywhere outside of neutral territory. We also have to look at the law of the sea. There's not a great deal of expertise, frankly, in the law of the sea, in as much as there is in other areas of international law. And when you're looking at what are the proper geographic areas for the law of naval warfare, the law of the sea provides those answers, both for belligerent activities that are beyond the territorial sea, and then what special rules might apply in different areas such as archipelagic waters, straits used for international navigation, and even special geographic areas such as Antarctica, the waters surrounding Antarctica. One of the larger hangups that we deal with in the Newport Manual is the treatment of the exclusive economic zone, that 200-mile zone that coastal states are entitled to for their living and non-living resources. There's a lot of confusion about borrowing too much from the law of the sea and putting it into the law of naval warfare. So these are some of these are the chapters, actually, 12 chapters. And with this, I'll just kind of close, just kind of hitting some of the highlights. We look at the application. The law of naval warfare is primarily applying to international armed conflict, but we also have Chapter 12 on non-international armed conflict that comes into play in situations such as the Israel-Gaza conflict, or more recently, the salient example of the Houthis launching anti-ship ballistic missiles, a technology developed by China 15 years ago and that has been acquired by Iran and now the Houthis. In addition to the areas that are governed by the Law of the Sea Convention, we look at the principles that apply at sea. In particular, proportionality and distinction are quite different. Just one quick example, proportionality at sea applies in the maritime environment, where proportionality is an analysis of what is surrounding the ship rather than the individual. And the ship is the target. Say a warship would be a target. And the law of naval warfare is a platform-based construct. And therefore, if you have, for example, 50 nuns on a warship, they do not figure into your proportionality analysis. Only if the warship, say, is at a pier and there's, a church next to the pier, for example, then you would have a proportionality analysis. And all of this has been developed over the centuries because people are not occupying the ocean. They are only on vessels and, by extrapolation, aircraft. We look at the means of naval warfare, including special rules, for example, on mining, and the methods, which are quite different. Blockade is somewhat analogous to siege, although it has different rules. And then there are designated war zones or maritime exclusion zones in which the operational commander can actually exclude neutral shipping from certain areas for a fixed amount of time. Targeting is also quite different because I mentioned that that it's a platform-based architecture, and therefore there's a very different view of direct participation in hostilities. Rather, you're looking at the platform and the conduct of the platform rather than individuals. So the only time in the law of naval warfare that you would have a DPH type of scenario would be if an individual, say, is attaching a limpet mine to a vessel, like a swimmer. But once they're in a vessel, then the entire ship would become a legitimate target. There's also issues of prize capture, which is entirely alien to the law of warfare on land. If you are going to requisition private property on land, you have to have receipts and payment and the rest, and that's actually not at all the case with the law of naval warfare. Law of naval warfare, you can take the commercial property of your enemy. And so with that, I think I will, I think I'm going to skip all the way to the end. I have another, I'll just close it here because I don't want to flip through all these slides, and we'll bring it up to the next one. Okay. But I just wanted to give an overview. You have the resource available. You can download it on the internet. We also do have some hard copies that you can order as well. But hopefully it's a useful tool. Thank you.
I'm going to talk about an issue that Dean Chang raised earlier about how China is trying to change the maritime landscape, change the rules that apply at sea. And one of the tools that they use to achieve that is the People's Armed Forces Maritime Militia. So where does the militia fit into China's armed forces? You can see here that China's armed forces is really comprised of three different organizations: the PLA, the People's Armed Police, and you saw them used extensively in Hong Kong most recently, and then finally the People's Armed Forces Militia is the third branch of the armed forces. The Chinese maritime militia is the largest government-sanctioned maritime militia in the world. And it is trained, equipped, and financed by local PLA military commanders along the coast. And the government will actually subsidize or rent out these private fishing vessels to perform official missions on behalf of the PLA Navy or on behalf of the China Coast Guard, either on an ad hoc basis or on a permanent basis. They fall directly under the PLA chain of command. You can see down here the maritime militia units have a direct line of command and control all the way up to the Central Military Command in Beijing. Right, the militia is used to assist both the PLA Navy as well as the China Coast Guard in times of peace as well as in wartime. In peacetime, they are used to do things such as sovereignty patrols in the South China Sea, as Dean Chang mentioned. They're trying to take possession of the territorial land masses that are within the 9-dash line or the 10-dash line, depending on how you want to describe it, in the South China Sea. They also are used to interfere with other littoral states' resource rights, like fishing vessels or vessels that might be out doing seismic surveys for oil and gas exploration. They might harass those types of vessels, or they could engage in maritime confrontations like the incident that again, that Dean mentioned about the USNS Impeccable in 2009 in the South China Sea. During wartime, they will be used to conduct missions that are in direct support of the PLA Navy, such as intelligence, surveillance, reconnaissance. They'll do targeting, provide targeting data, jamming, conduct military deception, combat search and rescue. They will be used to conduct both defensive and offensive mining, as well as sea lift and logistics support for the PLA Navy. Now, there are two categories of maritime militia vessels. There's the rented fishing vessels, and there's two categories of those. They have the small coastal vessels that are used primarily for coastal and harbor defense along the coast of China, as well as for intelligence, surveillance, and reconnaissance, and they're always used on an ad hoc basis. They're not permanently assigned this mission. They are fishermen most of the time, and then they may be chartered by the PLA or by the China Coast Guard to conduct ad hoc missions in support of the government. And then the second category in this in the rented category are larger ocean-going private fishing vessels that are used to provide direct support to both the PLA Navy and the China Coast Guard on an ad hoc basis. Again, these are primarily fishing vessels that are converted on an ad hoc basis to perform military or Coast Guard support missions on an ad hoc basis. The second category is these state-owned fishing vessels. And you can see here, this doesn't look like a fishing vessel at all. They have reinforced hulls. They have ammo storage facilities on board, weapons on board. They're manned by retired PLA Navy veterans. They are paid a salary independent of their fishing duties if they were to provide any fishing from these vessels. And they're all equipped with advanced communication systems and radars that are capable of communicating directly with the PLA Navy chain of command as well as with the China Coast Guard. And at the end of the day, they really don't do any fishing. Their primary and only mission is to provide direct support to the PLA Navy and to the China Coast Guard. So here's an example of maritime confrontation, the incident that Dean mentioned, the harassment of the USS Impeccable in 2009 in the South China Sea, operating in well outside of the territorial waters of any nation in the South China Sea. And you can see this this gentleman here is holding that boat hook, and what he's trying to do is he's trying to snag the cable of the towed array that's behind the ship. Now, not a real smart thing to do, because if he's successful in doing that, what's going to happen to him? He's going to go over the side, because he's not going to be able to pull that tow array in with a boat hook. So not a very smart move, but they succeeded in harassing the impeccable, making there were 3 maritime militia vessels involved that were under the direct supervision and command of a PLA Navy vessel, as well as a China Coast Guard vessel that were off on the horizon observing this harassment mission. Another example is incident that happened at Second Thomas Shoal, which is a low tide elevation that is within the Philippine exclusive economic zone, so within 200 miles of the main Philippine islands. And the Philippine Marines maintain an outpost on the Philippine government intentionally beached a old World War II landing transport ship at Second Thomas Shoal, and they stationed a group of about 12 Marines on there, and they get resupplied about every 6 months. And when they do that, they are routinely harassed by both the China Coast Guard and by the maritime militia. Sometimes they're successful in preventing the resupply of those Marines. Other times the ships get through. As I mentioned, they also directly interfere with resource rights of their neighbors. Here's an example of a maritime militia vessel ramming another nation's fishing vessel in the South China Sea. And they also assert sovereignty on behalf of the government. This is an example at Whitsun Reef, again within the Philippines exclusive economic zone. But you had over 100 maritime militia vessels that anchored at Whitsun Reef in order to assert Chinese sovereignty over that feature, even though it is a low tide elevation and is not subject to appropriation by China in the South China Sea. And then sovereignty patrols. So you can see here primarily the Hainan militia, the permanent maritime militia forces are routinely used to do sovereignty patrols to the 7 outposts that China maintains in the Spratlys. And you can see all those there with the red flags. Those are the 7 outposts that are artificial islands that they've created in the South China Sea over the last 9 or 10 years. And as I mentioned, they're also used in wartime. During the Chinese invasion of the Paracel Islands in 1974, the PLA Navy used maritime militia vessels to support their invasion, their amphibious assault against the South Vietnamese forces that were on the Paracel Islands, and were successful in ejecting the South Vietnamese, and to this day maintain significant forces in the Paracel Island group. Okay, so what does that mean from a naval warfare perspective? Generally under the law of naval warfare, you're only going to attack a military objective. And what is that? And it's an objective by its nature, location, purpose, or use, make an effective contribution to the enemy's war fighting, war supporting, or war sustaining effort, and its total or partial destruction, capture, and neutralization in the circumstances ruling at the time offers a definite military advantage. Well, our maritime militia vessels being used in that capacity. When they are on a direct support mission to the PLA Navy during an armed conflict, the answer is absolutely yes. They are a military objective, and as a result, they can be directly targeted. And as James mentioned, this is platform-based targeting. So we don't care that there's 20 civilian fishermen on board these vessels. They are targetable, and then they can be sunk without doing any type of proportionality analysis before engaging that vessel. Now, in 2019, Admiral Richardson met with his counterpart, the PLA Navy, and basically told him that we were going to treat maritime militia vessels the same, and their Coast Guard vessels the same way that we would treat the PLA Navy during an armed conflict. That has not had much effect, because we've seen the maritime militia and the Coast Guard continually harass their neighbors over the last 5 years since the Admiral Richardson made this statement. But we have to be careful about this targeting issue because China will try to exploit that during an international armed conflict. So you hear a lot about the China's three warfares, and Jill writes on this extensively. So if you want to read some good stuff, just read Jill's stuff that she has on China's lawfare and legal warfare. And it's really what they're doing is they're preparing the battle space so that they can get an advantage by using the law in both peace and war to ensure either a victory if war does break out or to accomplish an objective without actually going to war. So the example of this would be Hague 11 basically provides protection for small coastal fishing vessels that are operating along the coast. They're exempt from capture, they're exempt from targeting. However, the convention makes very clear that if these vessels are used or take a direct part in the hostilities, then they lose that protected status. But you can see China exploiting this every chance they get. If the U.S. were to engage a maritime militia vessel, kill 20 civilians, that's what's going to be in the CNN headlines is going to be U.S. kills Chinese civilians that were fishing. And so it's something that while it's legally permissible to engage these forces, we have to think about how we are going to counter this with our own counter lawfare when we do engage these types of vessels during an international armed conflict. And that's it. Thank you.
Yep, I can see it. All right, I realize I'm the last speaker of the day, and it is a Friday, so I'll try to be brief. Again, Robin Ellerbe, I'm the Chief of the Maritime and International Law Office for the U.S. Coast Guard. And what I'm going to do today is try and basically complement and supplement some of the things you just heard here from a practitioner standpoint on how we do it. We have a unique role as an armed service, but we're also a federal law enforcement agency, so we kind of see both sides of it. And just about everything that we do with as a member of the greater interagency. We like to talk about whole of government approach. I like to talk about a whole of globe approach because we have to do this with our foreign partner nations that we also work with to tackle some of these objectives that we're all trying to get after. I only have a couple of slides, I think really one, and have a couple transitions. Right now, very busy, sorry about that. It does kind of lay out our Coast Guard operational posture and priorities right now. As you can see, we are all over the globe. What you're seeing here in the colors and the blue and the different areas there are various areas where we're operating in. The dots reflect training exercises, attaches that we have in embassies. A lot of people don't realize the Coast Guard's very small, but we have a very large global footprint. We're only about 48,000 strong on active duty. That's give or take a year, right at the same size as the New York Police Department if you include their civilian employees. So we try to do the best we can with a limited amount of folks, but we try and spread it out as far as we can. So we actually bring in the interagency to assist us with this. One of the first areas that I was going to talk to you about is one of the things that most people know about what we do is that law enforcement piece when it comes to our counter-narcotics mission. A part of that is really tied to our efforts with DOD, especially the folks that we have down in Key West in the Joint Interagency Task Force South that work directly with us. DOD in that particular mission has the statutory authority to do the detection and monitoring for those missions that bring to bear multi-domain awareness capabilities that we don't necessarily have as the Coast Guard. As some of you might be familiar, when we stop board and search a vessel, we may be on a gray hull, we may be on a Navy vessel, we may be on our vessel, we may be on a partner nation vessel. We can do that through the use of law enforcement detachments that they're the teams that we put on Navy vessels, partner nation vessels. And with partner nations, we use bilateral agreements, which we have the treaty powers delegated to us from the president through the constitutional powers to create treaties, which allow us to go out to the Circular 175 process. It's delegated. We work through state to set up bilateral agreements with various countries. Right now, we have about 60 plus. They generally cover ground from search and rescue, which folks know, law enforcement, which can speak to even IUU fisheries, but also maritime pollution efforts, along with our counter-narcotics issues. Here, pictured in here, you see one of the drug hauls that we've had. This one, most likely due to the size of it, most likely came off of the semi-submersible you see there in the middle. The DTOs and the TCOs, DTOs being drug trafficking organizations, and the transnational crime organizations are multinational organizations. The reason it's a national security threat and remains such is that these organizations are destabilizing our partner nations to the south. As we see the impacts and the effects of that is that the destabilized countries, everything from Venezuela to Colombia to Ecuador to El Sal, will create economic instability for the populations that are there. And it's just one of the many factors that lead to the irregular migration that you're seeing at the southwest border. So the DTOs want to destabilize those governments that we work with. It's in their best interest to make sure that they are trying their best with the money that they earn from the cocaine trade through fentanyl now and through marijuana to feed back into the system. A lot of these, there's a point in case with the Mexican military. I always try and tell folks, a lot of times we're used to our U.S. Army, we're used to our U.S. military structure, where our Army, our Air Force, our Navy look outward to protect our nation. Well, with many of our partners, their militaries look inward to protect their country from the DTOs and the TCOs that are right within their border. So it's a very different construct that they're having to deal with, and we're trying to help them the best we can. But the money goes to corrupt many of the judiciary there, and when they can't, corrupt someone, they'll lead to assassinations, as in Ecuador, where the lead prosecutor was just recently assassinated in Ecuador, leaving a challenging situation for President Naval, who's in Ecuador, and causes sometimes, as you can look down in El Salvador with President Bukele, he's gone to very extreme measures to try and deal with DTOs and TCOs within his country. So we're trying to not have that same type of activities here within the U.S., but you have to think of it as the DTOs, TCOs, as being multinationals. They have subsidiaries right here in the United States that they're working with to continue that drug trade. With us, we see it in border security and different things where they not only are bringing the migrants through illegally, but they're trying their best to continue to destabilize the border so that they can continue to transport. It runs into the logistical supply chain as well. Anything that you can bring by plane, train, automobile, by sea, you can also bring something else in by that same vector, which the DTOs and the TCOs have been very good at manipulating. One of the other areas that we have been expanding into, utilizing DoD assets and other interagency assets as well, is into the area of IUU, the illegal, unregulated, unlawful fishing. As Professor Pedrozo was pointing out, the Chinese fishing fleet, to include the Maritime militia, is the largest in the world. China has over 560,000 fishing vessels that can be deployed around the world. Their deep water fishing fleet ranges anywhere from 3,000 to 4,000. What that means is that deep water fleet can come out as far as South America, the Galapagos, and 300, 400 vessels at one time can just en masse overtake a country's economic exclusive zone. And that's a finite resource that they're taking back to China, that money doesn't go into the national economy and further degrades that national economy and causes some of that economic and instability that I was talking about. So hopefully some of you have seen in the news, we recently had a cyber executive order that was just released here. I think Professor Cheng brought it up earlier, and I think Ms. Zolby also mentioned it about the Chinese manufactured cranes here. So the cyber EO that was just issued speaks to that. It gives the Coast Guard, the FBI, and the CISA some additional authorities to try and mitigate that threat. We have just announced a notice of proposed rulemaking that will be open through the end of April, I do believe. That will hopefully get comments from industry on how we can best attack this particular problem set. But in the interim, we'll be issuing a maritime security directive as well. That some of the details are security sensitive, so they aren't publicly available. But I can imagine that what we'll be telling the impacted crane operators and owners is that they're going to need to do some cyber hygiene, such as changing passwords, account security, network segmentation, and different things that we already do. The Coast Guard has cyber protection teams, which are a part of the larger U.S. Cyber Command that provide red teaming, hunt capabilities, assessments, and different things. Prior to this cyber executive order, most of that was done on a volunteer basis. We had to go in if we had some assessment that told us that there was a threat. We had to go contact the industry partner, seek their consent to come in and hunt, inspect, or red team. The new EO and eventually the rulemaking that will come out, the additional regs, will allow us to do a few more tools in the toolbox, we say. It won't necessarily be compulsory to a full extent for us. Anytime that we have to go in compulsory, we're going to have to, get search warrants, use the Fourth Amendment, go to the courts to do those things. So hopefully the process will be one that is received well by industry, and then they'll work with us. I think it was mentioned previously, the cranes here in the United States, 80% of the cranes are produced in the PRC. That is a large number. We have 361 ports here in the United States. So if you look at that footprint that they have already, is a huge vulnerability when you think that someone remotely can turn a switch and turn your ports off, essentially. So, and I hate to say it, but China's done a wonderful job of putting this footprint, not only in the United States, but around the globe. They own or operate ports in over 50 countries around the world. And they have a major ownership stake or operational concern in, close to 100 of those ports. In addition to the cranes that we were talking about and had concerns about, they also have a supply chain management software that they use called Logging that some of you may have heard about. And that also is, as Dr. Chen mentioned, it is an information data collation system that is really test our capabilities to keep our military outloads, our supply chain safe, because they know where everything's going better than we actually do. From the Coast Guard perspective, there is 90% of the goods that come into this country come by sea. It's a $5.4 trillion industry, and you're talking about China's ability to see, control, or shut off that capability. I'm prior Army before I came to the Coast Guard, and one of the things that I was trained a long time ago, I was a Cold War kind of person, dates myself a little bit, but we were taught that you always had to shoot, move, and communicate. And when you think about that, shoot, move, and communicate, and what we're seeing from, the folks in the great power competition now, is that China's done a outstanding job of trying to control that move piece and that communication piece. And they're trying to catch up to us in that shoot piece. So it is a ever-growing threat that we are trying to continually assess and keep up to, and which makes us have to work with the entire interagency to include NGOs, which we're trying to. I see the general is standing up.
Yeah, please finish, Robin. I was just getting ready to field some questions.
Nope. All right. I will
field
stop.
the questions.
I will
identify
stop
the question.
here. I will say If you really want to talk about the great power competition, that's Tobacco Road and the Duke, Wake Forest, State, and Carolina thing. We can do that at the.
Yeah, we're going to do that at the Washington group. I think everybody can see why it was so important that we have this maritime panel. When you hear about the connection with trade and you start thinking about the commissioner when she was talking about, commerce and so forth, commerce is really, anybody thinks that's not integral to the whole national security equation isn't really paying attention. Start thinking of questions. I'm looking right at you. But let me throw out a few to get to, chum the waters, since we're talking Navy stuff. That's something they do in the water, I think. But a couple of things, especially about maritime law. The DoD is coming out with this civilian harm mitigation and response plan, which to me does not, I can't remember any recognition that there's a concept of maritime law embedded in anything that they're doing. Perhaps others would know better than I, but I've looked through the documents. I don't remember anything, and especially because the very different way that you do targeting under naval law. So, then my second question, and this is for anybody, is I'm really concerned about the impact of neutrality in the war in the Ukraine and how that is going to affect naval neutrality. In other words, an interpretation of international law in one context might have unintended consequences in another. And Robin, just for I always have the impression that, a Whitehall ship is much better to work with a lot of partners. Is that true? And do you have enough hulls really to execute that strategy?
Would you like for me to answer right now?
Yeah, why don't you start?
So I would agree with you, sir, that Whitehall's, we've had a great relationship around the globe. We can go places that our Navy counterparts can't necessarily go, and that's literally written into the bilateral treaties that we work in. When we negotiate them, there are times that they sit there, they tell us we will allow Coast Guard in, but we do not want a Great Hull in, because they see it as a threat to their sovereignty for whatever reason. For the Whitehall, they don't, because
Whitehall is a Coast Guard ship.
Coast Guard cutters.
Grey Hull is a Navy ship.
I apologize. Yes, sir. Thank you for the clarification. A lot of the reason is that because of the missions that we do, because we're seen as a search and rescue multiplier around the globe, we have agreements with everyone. And in international law, and Kraska can attest to this, when you're out on the sea, it's everyone's responsibility under SOLAS, the Safety of Life at Sea Convention, to come to the aid of another that's in distress. And oftentimes that's the Coast Guard. And it can be the Coast Guard off the Atlantic, off the Pacific, it could be off the Red Sea. We actually have 6 cutters that are stationed out in the Bahrain area currently right now that do all of our missions, but they will also do search and rescue if necessary. And so because we have that that relationship with so many people, and including China and Russia, we still have agreements in place with China and Russia. We are allowed in a lot of ports where we wouldn't otherwise be welcomed.
Gentlemen, on the other 2 issues?
I can say just a word or two about maritime neutrality. So, and we talk about this extensively in the Newport Manual. Neutral states have rights and they also have duties. So they have the right of inviolability of their commerce, but they also have a duty of impartiality. And belligerents have corresponding rights and duties as well. They have the right to insist that the neutral state really does abstain and is neutral. And then they have the duty to respect neutral vessels. They also have an additional right. They have the belligerent right of visit and search of all neutral ships, neutral merchant ships, not sovereign immune vessels, but neutral merchant ships. So if you have a cargo, combat cargo on a contract vessel that's not a sovereign immune vessel, then that ship, if it's heading toward Ukraine, is subject to Russia's belligerent right. It's an unmitigated right to visit and search that ship and seize the cargo if it's contraband. That hasn't happened for political reasons, but not for legal reasons. Russia would have the legal right to do so. We also talk about another theory, sort of a minority position, which is, well, there's a qualified neutrality in which states might side with one of the belligerents that's the victim state. In this case, let's say Ukraine, and therefore those traditional laws of neutrality are not, don't apply. The Newport Manual is not doctrinaire. We have both views. It's not like some manuals where we say rule number 1 is this, rule number 2 is that. As long as it is within the boundaries of the acceptable state practice as it's developed through the centuries, then we include that. And so we have both of those perspectives on maritime neutrality.
Yeah, and the Russians have actually done one visit and search in the Black Sea. It was a classic visit and search. A vessel came through the Bosphorus, through the Turkish Straits, was headed up towards Ukraine. It was boarded by the Russians. They didn't find anything on board and they let it go. It was a classic visit and search by the book, belligerent right that they exercised. On qualified neutrality, I've written on this, and my personal view is I think it's nonsense. So either there is or there isn't neutrality, and the fact that Russia hasn't done anything about it is because they're not in a position to do anything about it. So they're not going to shoot down a aircraft that's bringing weapons into Ukraine, U.S. military aircraft, for example, because they know that that's going to bring NATO to bear. So they're not going to exercise their right of self-help to stop a neutral from violating their impartiality. And just remember that not every violation of neutrality makes the neutral a party to the conflict. It has to be something that crosses the threshold, like an attack kind of a thing. Then the neutral would lose its status as a neutral and would become a party to the conflict. And so far, we haven't seen that. Now, that could happen. You saw some press reporting when they sank one of the Russian flagship, that there was some reporting that the U.S. had provided the targeting data to the Ukrainians. If that is true, then we have violated our neutrality, and that would cross the threshold in my mind, and we would have become a party to the conflict. Now, whether that's true or not, that somebody was talking about the press, taking the law and writing stuff, and they don't know what they're talking about. So we don't know what the truth behind that are. But if we did in fact provide targeting data, I would say that we would become a party to the conflict. On the issue of civilian harm mitigation, I think that whole document is written in the context of what we've experienced over the last 20 or 30 years in counterterrorism operations, urban warfare. There was no thought given to its applicability in a naval context, in a law of naval warfare context. So if you've got two warships at sea, and one of them has civilians on board, I don't think the civilian harm mitigation process applies in that situation.
You probably ought to say that. But anyway, Michaela, I know she has a question.
Yes, sir. Good afternoon. I'm McKeely Hansen from the Air Force Academy. And my question is, do you have any concerns with or foresee the U.S. facing any challenges maintaining a strong influence in the international community with maritime law, considering we haven't ratified the UN Law of Sea Convention?
Very good.
Pete and I both have, you go first on this. I mean, we've written on this and we're like-minded.
The fact that we're not a party to the Law of the Sea Convention isn't going to solve anything. If we were to join the convention tomorrow, China would still not comply. They would keep doing the same things that they're doing, and we would be in no better position than we are right now. In my mind, if we were to join the convention, it's not a bad thing. It's not going to really hurt us. But if we don't join the convention, we've lived outside the convention for 40 years. We've been doing fine outside of the convention for 40 years. And if we stay outside the convention, then our position is not any worse than it is if we're a party to the convention.
I agree, but I think there are some other benefits, though, particularly in light of the pandemic and supply chain security. What I'm thinking about is deep seabed mining and strategic minerals, in which China has not a monopoly, but about an 80% market share in rare earth metals and strategic minerals. And China seems to be using strategic in a military context. They seem to be strategic in where they have sought deep mining sites. For example, in the Indian Ocean, they have two, one to the left and one to the right of India. And it's certainly an excuse for them to be able to develop their deep water capabilities, and also to operate on the seabed in the vicinity of other countries. So I think there are some benefits, some concrete benefits, not just sort of political or diplomatic benefits. There would be some concrete benefits to joining the convention.
Robin, do you have any observations on that, on whether we're members or not?
Yes, sir. From a practical standpoint, when we are working with our partner nations, it's a subject that's often brought up. Now, when we are the bilats that I was just mentioning, most of those are still based upon UNCLOS parts and articles. When we don't have a bilateral agreement in place with a partner nation, we use the Article 17 process, which is a part of UNCLOS as well, to engage with the country to then set out the left and right limits for how we're going to approach a flag state's vessel, which is considered to be sovereign. We know that this is one of the dynamics that we have oftentimes, where as the Coast Guard, we try to remain lockstep with DOD and Navy on these things, so we always work together on them. But we are finding, I'll be going to the International Maritime Organization in March, and there will be a pitch again for us to join and ratify the convention. I think, I can't remember which senator right now in November tried to push again for the ratification again. But we're definitely utilizing the UNCLOS as customary international law. Most of the nations that we work with understand that we're abiding by UNCLOS. The real issue has been seabed rights, which Professor Kraska brought up. But there's going to be a point in time that if we're not at the table, PRC may be able to manipulate that in their favor.
Any other questions? All the way in, is that you, Andrew? I can't quite see.
Hi there. My name is Andrew Parko. I'm a 2L at UNC Law. My question is for Southeast Asian states that are threatened by Chinese aggression in the South China Sea, like the Philippines and Vietnam. What sources and tools of non-kinetic lawfare should they be using to reassert and legitimize their sovereignty on the international stage?
What are the Southeast Asian nations doing, or what's China doing?
What should they do?
What tools should they, non-kinetic tools, lawfare type tools should they use?
Okay, well, I mean,
That they haven't already, I guess.
China doesn't like to be publicly in the limelight. So one thing that states could do is, every time that there's a violation of, let's say, the collision regulation, that ramming of a ship, that's a violation of the collision regulation. I go to the IMO, I'd stand up at the IMO, and I would raise that as an issue. When they interfere with a surveillance aircraft and do something that violates or that violates the Chicago Convention, I'd go to ICAO. At the ICAO meeting, I'd stand up and I'd raise the issue. You go to the fisheries, FAO, the FAO, same thing. When they're doing IUU fishing, stand up and criticize them publicly. So that's one thing that you can do. Does China care? During the South China Sea arbitration, they refused to participate. They lost that case. The tribunal ruled in favor of the Philippines in every respect, and China has refused to comply. So it's really, that's a mechanism that's not enforceable. The compulsory dispute settlement under the law of the sea convention is a great idea, but it's meaningless. Because if the country like China doesn't comply, the only enforcement mechanism is the Security Council. And if it's China or Russia that's involved, they're going to veto any kind of resolution. So compulsory dispute settlement is a nice thing, but it only works to the extent that countries will abide by the decision. And most rogue nations like Iran, North Korea, Russia, China aren't going to comply with the tribunal decision.
Okay.
One other thing that they could do is the other claimant states in the region, principally Malaysia, the Philippines, and Vietnam, if they could have a mini-lateral agreement and sort out among themselves, then that would have a great normative power, and it would, provide quite a setback for China.
Riley, do we have somebody? I always do what Riley tells me to do. So.
Second class Ruggiero, United States Coast Guard Academy. With the United States recently making a claim to an extended continental shelf, do you think this could be the catalyst to join UNCLOS?
Yeah, what does a continental shelf mean to the masses? Why would that even be important?
Well, the intercontinental shelf is essentially it's the nation's claim to the resource rights of the seabed extending out through essentially the exclusive economic zone, which is 200 nautical miles, and from the coastline of the particular nation. In our case, we just extended our continental shelf out in certain areas out by Alaska and some other areas where those areas have been considered to be international, the high seas for the most part, which could be minerals and resources could be extracted by any nation. By undertaking to extend our continental shelf, and we're doing that under the international law, we believe that we have, based upon how we draw baselines and how it's been laid out to draw the continental shelf, we think like we have a good argument for that. We have essentially set the country's bar for the protection of our natural resources. I think Professor Kraska mentioned it before. Here off the coast of the Gulf Coast right now, there's two projects that China's trying to get pushed through. They'll have to go through the CFIUS process, where they're trying to put oil wells into the Gulf off of Mexico and then in another location. And we go through a process of trying to vet that particular situation to make sure it's not Chinese majority owned. I think both applications will get disapproved, very likely. But it is a issue of finite resources, again, and which we're trying to protect through the extension of our continental shelf.
Well, thank you very much. This has been a fascinating panel.